So the topic is very, very important. Meaningful research and IPRs. Research is only meaningful when it is done for the benefit of the society, for the benefit of the human beings, for the benefit of the entire world. And in this context, when we do a meaningful research, it is also important that those who are putting a lot of hard work, efforts, spending a lot of money, a great amount of funding is required for good quality research. So it is also important that whatever meaningful research has been done, it should be properly utilized. It should not be misused. It should not be uh, a researcher should not feel that his ideas or his thoughts are stolen or being misused. So in this context, when we talk about intellectual property, basically it refers to creation of the mind, such as inventions, literary and artistic work, designs and symbols, names and images used in various activities. And there are various ways of protecting this intellectual creation of the mind, human mind. Uh, the literary work can be uh, and artistic work can be protected by copyright. Then you can uh, protect your innovations through patent. You can protect your trade designs, trademark. You can put visual designs of your trade through trade dress and definitely whatever secret, trade secret you have, commercial interest secret, you can protect by trade secret, and also with the geographical indication, like when we talk about orange from Nagpur. That's a kind of branding. We have seen cases of basmati rice and all those things, turmeric and all those things. So in this context, it is intellectual property right is a very, very important topic and very, very useful for researcher to understand that whatever research you are doing, you also need to protect it. It is a very broad topic. In my keynote address, I'll be restricting on the academic research because it is not possible to talk on all the aspects in such a short time. So when we talk about copyrights in academic research, as a researcher, we have different ways of protecting and safeguarding copyrights. Like we are, as a user of information, we are supposed to respect and protect the copyrights of others. As a research disseminator of information, we are also supposed to protect the copyrights and other rights of others. But when we talk about creator of information, researcher as a creator of information, we have to protect our own copyrights, our own intellectual creation. So in this context, it is very important to understand various dimensions of copyrights. Like when we are using certain information, we should clearly understand what is this fair use. Like when you are using somebody's material, uh, you are using in classroom, you are using in research, for individual research, for group research, for institutional research. So there are certain way of using certain material, and for academic and research, fair use is a very, very important topic and very, very important provisions. I think because of this Delhi University case was uh, given in the favor of university and the photocopying operator. So in this uh, we need to understand, we need to educate our researcher that how to protect this fair use. And there is no clear cut definition of fair use provided in any copyright laws in India or abroad, but there are various ways of determining the fair use. So how to determine this fair use, you should know about. As a researcher, as a teacher, as an academician, everybody has to understand how to measure fair use. So when you determine whether fair use exists, course look into the whether the use is transformative by examining four factors: the purpose and character of the use, including whether such use of a commercial nature or is for non-profit educational purposes. The second is nature of copyrighted work. The third is amount and substantiality of the portion used in relation to the copyrighted work as a whole. And the fourth is the effect of the use upon the potential market for or value of the copyrighted work. So whenever we talk about any kind of use of material, these are the few things which we should keep it in mind. Now, researcher as a user of information, there are certain other things. You need to protect the copyrights of others. You need to respect the copyright of the others. Like when you are photocopying, making course pack, you are downloading any material, you are downloading various kind of digital. Like we need to understand many times there may be some kind of freely available material, but the freely material cannot be circulated in group or in the masses without the permission of copyright holder. So there are certain kind of copyright restrictions which we need to understand. We also need to understand that in this digital world, when we talk about databases or e-journals, this systematic downloading is also a kind of offense, and it comes under various kind of licensing. So like library, when subscribe something, sign lot of license agreement, and in this context we need to understand those license agreement. Now researcher as a creator of information, so there are three important things which a researcher should understand to protect your copyright. Like traditional copyright, what is covered under Indian Copyright Act, because land of law is the first one to. According to the traditional copyright, work cannot be used, adapted, copied, or published without the creator's permission. So, what does it mean? It means the original work is to be protected under copyright when it is created under the copyright law. Now, there are some other provisions like Creative Commons. Like you may be having certain copyright restrictions, but there are certain provisions through which work may be used without permission, but only under certain circumstances, where a creator is setting certain rules for the way the work is used. So here, as a researcher, you have certain authority. You may be publishing an article in elsewhere journal or in any public commercial publication, but there are certain ways you can keep certain rights with you. This is the very important thing, and I'm sure Shipra and Ashish ji will be taking care of some course classes in this particular on Creative Commons, because it is very important for researcher to understand this Creative Commons licenses. Uh, in this Creative Commons license, only work that creators have chosen to designate as a Creative Commons license can be used. Now, the next third thing is the something in public domain. The work can be used, adapted, copied, and published completely without restrictions, no permission needed. So there are number of resources available on internet and other places where permission is not required. Take example, World Bank data. World Bank has given a complete license to make use of the data, World Bank data, for any purpose, including commercial purpose. So that is the one way. Another public domain definition is that there are certain copyright has certain life and laws. Like copyright can be restricted for certain years, maybe for in India it is about I think 60 or 70 years of after the death of author. So in this context, it is important to understand that uh, you should when the copyright is over, it is out of copyright, and that become the public domain document. So all these three things are very important for researcher to understand. Now when we talk about all those things, let's understand a copyright owner's rights. The primary goal of copyright law is to protect the time, effort, and creativity of the work's creator. As such, the Copyright Act gives the copyright owner certain exclusive rights, including right to reproduce the work, prepare derivatives, work based on the original work, distribute copies of the work by sale, lease, or other transfer of ownership, perform the work publicly, display the work publicly. So these are certain exclusive rights given to the copyright holder, and suppose somebody else is using this, that's a violation of copyright. There are certain provision in the copyright when the rights can be transferred. The copyright owner can decide to authorize somebody, some people or some organization, uh, to give those rights, uh, and the copyright owner has option and ability to transfer his or her exclusive right uh, or set up some rights out of that. Like if an author or artist creates a work of a company or in the course of his or her employment, the creator is usually not the copyright owner. The situation is known as, and it gives copyright ownership to the employee or person who's commissioned the work. For example, of thesis and dissertation, a student is creating thesis and dissertation, so exclusively as per the copyright, student is the copyright holder. But university, by being the funding agency and by the virtue of the grant agency, it has certain rights to make use of the thesis for academic and research purpose without the permission of the student. Copyright law of India, which was like we need to understand two things. Prior to 21 January 1958, the Indian Copyright Act 1914 was applicable in India and is still applicable for works created prior to 21 January 1958, when the new act came into force. The Copyright Act of 1911, passed by the Parliament of the United Kingdom, as modified and its application to India by the Indian Copyright Act 19. Copyright Act 1957, which has been revised, amended from time to time. The latest amendment is in 2012. So all the provisions of this are applicable. In addition to that, there is something called International Copyright Order as amended in 1919. So copyright of works of the countries mentioned in the International Copyright Order are protected in India, as if such works are Indian works. The term of copyright in a work shall not exceed that which is enjoyed by its own country of origin. So that is the kind of restrictions on this. And the duration of copyright vary from one to another. Like in case of India, as per Copyright Act 1957, lifetime of the author plus 60 years from the beginning of the calendar year next following the year in which the author dies. Similarly, for anonymous work, posthumous work, cinematographic film, sound records, government work, public undertaking, international agency, photographs, until 60 years from the beginning of the calendar years next following the year in which work was first published. But there are certain other copyright exception which has been given in the copyright law, which we need to understand and we need to study. And because of paucity of time, I will not able to talk about those copyright exceptions. So in every country, there is a different time duration of the out of copyright provisions, like starting from 25 years to 100 years. All these things are applicable in different countries. So apart from protecting the copyright, it is also important that we should understand that how we can give certain exclusive right for use of our material without the permission of the copyright holder. Is in this context, these creative common licenses are very important. It is an internationally active non-profit organization that provides free licenses for creators to use when making their work available to the public. These licenses help the creator to give permission for others to use the work in advance under certain conditions. So in this context, all rights are not reserved. Some rights are reserved. That is the basic meaning of the Creative Commons license. Apart from that, there are a number of other public copyright licenses, but I will not discuss more in detail. I will just give you some brief idea about Creative Commons licenses. So Creative Commons licenses, there are about six categories apart from public domain. So in this, attributions are different, like attribution CC by. This license lets others contribute, remix, tweak, or and rebuild upon your work, even commercially, as long as they credit you for the original creator. This is the most liberal Creative Commons licenses where you are allowing everything. Then CC by SA, this license get some more little restrictions, like if you share a like and it is not for commercial use, then you have to give copy left free and opens other provisions. Similarly, CC by ND, similarly CC by NC, attribution non-commercial share alike, CC by NCSA, attribution non-commercial like no drive, CC by NC, NDA. So one need to understand all these 6-7 provisions of Creative Commons license, and you are free to choose, like how you can choose this Creative Commons license. Nowadays there are certain publishers who allow you to keep certain rights with you. So in this form, copyright form, when you are signing a copyright form, you can make certain provisions. Or if you are publishing in open access, there are certain journals which have certain kind of such licenses. There are some repositories. So all these things need to be understood. And this public domain consists of all the creative works to which no exclusive intellectual property rights apply. That's why we say everything is in public domain. Now, apart from these copyrights, there are certain moral rights. One need to understand that there are certain ethics, and those ethics uh, are called ethics, research and publication ethics, or research ethics. This plagiarism or research and publication ethics are different from copyrights. Copyright is about protecting rights of creator of information. It is to protect unauthorized or unlicensed copying of a work subject to copyright laws of a country. Plagiarism is using someone else's work or ideas without giving proper credit. So here it is the violation of academic norms, but it is the violation of IPC code of conduct where punishment can be given. Plagiarism is applicable to only the copyright is applicable to only the licensed contents, but plagiarism is applicable to even unpublished material, the oral information, any kind of information which is known to various people. So we need to understand that copyright is having certain land of laws or certain things, but plagiarism is more about international convention practices and various kind of ethical norms. You don't require anybody's permission to quote in case of like plagiarism, because right to quote or right of quotation or quotation right is one of the copyright exceptions provided by the Berne Convention Article 10. So whenever you are giving a quotation, because in quotation you have to give verbatim, you have to copy the entire text. So in this context, you don't require any permission. You need to follow certain citation rules in the regard of this particular thing. This research and publication ethics, which are also moral rights. And in this moral right, we have to see this research misconduct play a very important role. So this fabrication, falsification, and plagiarism, all these comes under moral rights. So one need to understand these moral rights and should protect and should understand how to avoid plagiarism, how to avoid unintentional or accidental plagiarism, how to avoid self plagiarism. So I'm sure beside copyrights, this avoiding plagiarism or falsification or fabrication, all these research misconducts are also important. Apart from these literary works, there are certain other ways, like if you want to uh, deposit your article in a repository created by your university and institutions, it is also need to be understood, like because there are certain rights given by certain publisher that you can deposit your preprint or you can deposit after 6 months some embargo period. There are certain rules, and I suggest the participant should be explained about this Sherpa Romeo website. And basically it is an online resource that aggregates and analyzes publishers open access policies from around the world and provides summaries of publishers copyright and open access archiving policies on a journal by journal basis. So I'm sure Shipra and Ashish will be taking care of making people understand about these copyright and open access archiving policies. Uh, then there are certain things like traditional knowledge system. Professor Sukla talked about India, ancient knowledge system and research being done in ancient Indian time. Yes, it is true. More than 10 million manuscripts available in India are the great example of our intellectual creations. Although those manuscripts were not part of any kind of copyright and other things. Now, still there are certain kind of confusion in mindset. Let me clear, cultural heritage, which is thousands of year old, is beyond these copyright provisions. So, and many times there is no clarity what is the copyright, which is in under copyright, which is not in the copyright. So to overcome these issues of cultural heritage, there is an organization called Right Statements. It is similar to Creative Commons, and that organization has decided to come out with a certain kind of rights statement. And these right statements are exclusively for cultural heritage, like manuscripts or intangible cultural heritage or tangible cultural heritage. So in this uh, right to statement, there are three categories of right statement. One is in copyright, uh, second is no copyright, and other. Which, so basically, when you are aware of the copyright, then you mention this copyright. When you are sure that there is no copyright on this particular under this particular heritage, you can put this no copyright symbol. And if there is you have doubt, you are not sure, then you are not very clear about the copyright of this particular resource, then you put this right statement question mark. So these question marks are mainly to indicate the status of copyright, like it is in copyright, or it is there is no copyright on this, or it is doubtful case of copyright. So in this context, I think some section on some class on right statement may also be taken up. So I think I will not take more time, because there are number of other speakers who are going to talk about various issues on copyright. My to conclude my suggestions to the participants of this particular course, please try to understand that uh, doing research is important, publishing research is important, but at the same time, it is also important to safeguard your rights, uh, your copyrights, your other intellectual provisions of uh, 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 like it may be patent. You also need to understand that when you go for patent, what is the stage you should apply for patent, what are the other innovation provisions in this regard. So I'm sure this particular uh, program is going to help you in understanding that for a for protection of the results of a meaningful research, it is important to understand various kind of intellectual property rights. And I'm so glad that Ramanujan College Teaching Learning Center thought of having such an important topic, and participants are going to benefit from the experts in this program. With these words, I once again thank you very much. Namaskar. All the best.